Good morning and welcome to Dorsey and Whitney's webinar regarding municipal securities disclosure. We're glad you could join us today. Just some housekeeping types of items as we get going. You're going to hear voices today. There will be three primary presenters. Myself, this is John Danos. My law partner, Dave Grossklaus, will also be presenting a segment of the main presentation. In addition to that, our partner, James Smith, is also with us today, helping to monitor your questions. To that effect, we do want to encourage you to email any questions that you might have throughout the program to James's email address, which is smith.james@dorsey.com. That's smith.james@dorsey.com. So any questions that come up or that you may have brought with you today, if you'll email those to James, he's keeping an eye on that email address throughout the presentation, and we will do our utmost to try to get to your questions during our allotted time today, and if not, to follow up on those by email subsequently. So our agenda for the morning is to try to cover as much information that we think will be useful to you regarding municipal securities disclosure for the bond issues that your issuers do. To that end, we're going to start off by covering some basics regarding disclosure, just to put it into perspective, try to make sure everybody's on the same page about why we're talking about this and what we mean. We'll also highlight some recent amendments to the regulations that are impactful for issuers. So we'll try to put a spotlight on those for you. We will then move into discussion about the evolving role of the SEC and talk about the importance of the adoption of policies and procedures for your bond issuer. And finally, as noted, we will use any remaining time to try to address questions that you've provided to us during the program. So why don't we start off by discussing a little bit about disclosure basics, just kind of as an overview of what we'll try to hit with this. We're going to highlight some glossary definitional type items, again, just to try to make all of this a little bit more interpretable for you. We're lawyers. We can't help ourselves. We will talk a little bit about the role of legal counsel when it comes to bond offerings and, in particular, the securities-related issues that come along with those credit deals. And also in the basics section, we're just going to try to give you some initial understanding of the federal regulatory framework that we deal with in this arena. Why don't we start off with giving some meaning to some of the jargon that we throw around. And I'll apologize on behalf of all the lawyers and other professionals who make our living doing these municipal credit deals. We know we devolve into throwing jargon around all the time. I want to encourage all of you as consumers of those services to never be hesitant to call a quick timeout when you can and ask somebody what they mean if they're losing you. But for purposes of helping to guide your way through our program today, let's run through this glossary of terms briefly. You've already heard me using the word issuer, which is probably not a term that you run around in your daily life using. When we talk issuer in this context, we're talking about the governmental entity that is the issuer of bonds. We speak often of underwriters of bond issues, or sometimes also referred to as investment bankers. These folks are participants, critical participants in bond market transactions. Whenever bonds are being sold, there inevitably will be an investment bank underwriting that bond issue. They will be the initial purchaser of the bonds and will typically be then reselling those bonds out to investors. We speak often also of municipal advisors or municipal financial advisors. These are consultants who are, again, critical to these bond transactions. In their consulting capacity, municipal advisors advise the issuer of the bonds about financial related matters for the bond issue, and also about structural and procedural matters related to municipal securities offerings. You will hear us speak of the SEC, kind of an important entity when it comes to our topic for today, maybe more than just kinda. The SEC is the Federal Securities and Exchange Commission, which is charged with enforcement of federal securities laws. They are and have been very, very active in the arena of the sale of private corporate stock in the stock market and private corporate debt in the corporate bond market. They are also the overseers of our municipal bond market that your issuers participate in. In addition to those important parties, there are also some very important documents that you're going to hear us talk about today, so I'll draw your attention to the right-hand column on that page. You will hear us over and over again speak about official statements. In their initial form, these documents will be referred to as preliminary official statements, or abbreviated to POSs, preliminary official statements. These documents are the original offering documents, or prospectuses, if you'd like to use that word, that describe the financial position of your issuer and the debt that your issuer is offering when it is going to sell a series of bonds. As you might imagine, this offering document is a critical document in describing the securities that your issuer is putting out to the bond market, and is the subject of a fair amount of the regulations that we will discuss today. So that's what an official statement is. Starts off in preliminary form, and then after your bonds are sold, it gets evolved, if you will, into a final official statement and really becomes part of the public record regarding your bonds. You will hear us talk about continuing disclosure certificates or continuing disclosure undertakings, often abbreviated to be CDCs. These are another critical document when it comes to securities regulation of your issuer's municipal bonds. As the name suggests, this is the document that deals with disclosure of information to the municipal bond market about your issuer and their bonds after the bonds are sold, but while they are still outstanding. So until they are paid off or retired, this continuing disclosure certificate sets forth the obligations of your issuer to provide ongoing information to the municipal bond market about the bonds. There are also documents out there that are called dissemination agent contracts or agreements. This is a services contract that will run between your issuer and a dissemination agent. What's a dissemination agent? This is a person or entity employed by your issuer through one of these services contracts to assist your issuer with the ongoing, continuing disclosure requirements that are outlined in that CDC that I just described to you. And oftentimes a dissemination agent might be someone who also does municipal advisory work or investment banking work, but invariably you want that to be somebody who has good knowledge of the municipal bond market and the inner workings of securities disclosure in this context. Let's turn our attention now to just talk briefly about the role of legal counsel, just to try to give you folks some better understanding of what we as lawyers bring to these transactions. Many of you are used to referring to lawyers like us as bond counsel. You may have some other adjectives that you also like to use to refer to us, but bond counsel is what we are commonly referred to as. And that has been the traditional role that lawyers like us have played with respect to these deals. As bond lawyers, our primary responsibilities on your bond offerings are to make sure that the federal tax regulations are being attended to appropriately if your issuer is intending to offer tax-exempt bonds to the bond market in order to try to get that interest rate advantage. Bond lawyers look in on the federal income tax related issues. Bond lawyers also look in on the state law regulatory issues. As many of you are keenly aware, there are often intricate games of hopscotch that have to be maneuvered in order for your issuer to lawfully enter into a particular credit transaction. Bond lawyers are charged with helping their clients to navigate those games of hopscotch. And at the end of the transactions, bond lawyers are called upon to give a legal opinion. More often than not, both to the issuer as the bond lawyer's client and also typically to the investment banker or the lender on a transaction, opining that everything has been done appropriately with respect to both the state law regulatory and the federal tax issues. That's the traditional role of bond counsel. In addition to that, particularly over the past decade, we as bond lawyers have been called upon more and more frequently to assist issuers like yours with the federal securities regulatory aspects of bond offerings. We call the roles that we play when asked to do so our disclosure counsel roles. As disclosure counsel, we would typically be hired, like we are as bond counsel, to represent the issuer of the bonds. As disclosure counsel, we help to assess risk that might be associated with the bond offering and perhaps with the issuer's particular credit situation. And when we talk risk, we're primarily talking risk that we might need to notify potential investors about. We assist with the preparation of that official statement in its preliminary and then final form. or if we're not preparing it, then we assist with a close review of that document. We do a deep dive into your issuer's past and current compliance with previous continuing disclosure undertakings and prepare a report in that regard, in no small part because if there have been any problems, then it's incumbent on your issuer to report those problems in the official statement. And so we help to do a deep dive into that. And then like our role as bond counsel, we are often called upon as disclosure counsel to give an opinion at closing of your bond issue. It's called a 10b-5 opinion. You can throw that around in your personal life, by the way. Everyone will be very impressed. 10b-5 opinion. That's a reference to the securities regulation that of course sort of drives all this. We'll allude to it in more detail. We deliver an opinion at closing that things are in good stead with respect to that regulation.
And John, if I can just interject here for a minute, this is Dave Grossklaus. So we do have folks on this call from across the country. This dichotomy between bond counsel, which I think in the past has always been viewed as a role involving all aspects of a financing in the municipal sector. This dichotomy now between bond counsel, who's dealing in the most basic sense with state and tax law issues, and disclosure counsel, who is dealing with securities laws issues that we're talking about today, that has now become a fairly widespread phenomenon across the country. And so for some folks, in some parts of the country, it's a slightly new concept, but I think over especially the past 18 months to 2 years, it's becoming quite prevalent that bond counsel is making it very clear in their engagement letters with you folks as to whether they are or they are not also providing you disclosure counsel services. So you should, as an issuer, pay particular attention to, is somebody representing you with respect to securities laws matters?
Thank you, Dave. Let's jump into sort of the why we have to be attentive to these matters. We operate, obviously, in a system where we have federal regulations on a lot of things in life. No exception to that are municipal bond offerings. Under the 1933 Act and the 1934 Act, we have an anti-fraud provision that's housed in SEC Rule 10b-5. You heard me reference the 10b-5 opinion that this is the regulation that governs. And at its core, it's not terribly complex. It simply says that in your official statements, and for that matter, any other public statements, when you're offering bonds, that you're not, as an issuer, going to put out any false or misleading statements or omit any material fact that's relevant to that credit offering. Materiality, or the word material, it is a slippery term of art. It means a substantial likelihood that a reasonable investor would view a fact as significantly altering the totality of the information that was made available. I don't pretend that you're going to understand the word material just based on that last sentence. We're all figuring it out as well because it evolves with SEC rulings. But know that if something is just a complete irrelevancy, and you spell the word "it" wrong in a document, you're not going to run into trouble because of that. The misstatement or the omission does have to be material. This is important, and Dave will get into more detail in the back half of this presentation on this, but please do know that the consequences of fraud allegations, if they're borne out, can include civil penalties, so monetary damages, and it can also include criminal penalties, and of course, the corresponding credit and reputational harm that would come from that type of allegation being borne out and known publicly. Who can be liable? Well, governing body, so a city, your city council, a county, your board of supervisors, a school district, your school board, etc. The governing body can face these allegations and penalties, as can staff, employees, elected officials, in addition to the sort of entity itself, the actual issuer. And of course, the investment bankers who participate in these transactions can also face liability. So SEC Rule 15C212 regulates underwriters directly. There is actually more regulatory attention paid to the investment bankers on these, and your issuers indirectly, in particular through your continuing disclosure undertaking. Underwriters are charged with reasonably determining that the issuers of the bonds they are going to underwrite commit to providing continuing disclosure on an ongoing basis. That's housed under that CDC we mentioned. With respect to continuing disclosure, there are two aspects. One is annual reporting, which for the typical issuer that has audited financial statements prepared every year, your annual reports will include those audited financial statements when they become available. The second aspect of annual reporting is to provide an updated version of the financial and operating data that goes into your preliminary and final official statement. So just by way of example, let's pretend you have a chart that relates to, it's a property tax-based deal and it relates to valuations in your taxing jurisdiction. That might be the kind of chart that you would be expected to update with your annual report so that the investors who might decide to trade for your bonds 5 years into the deal are provided fresh and updated information, just like the initial purchasers of the bonds were 5 years earlier. The second aspect of continuing disclosure deals with material events. These are more real-time events that might happen at any point in an annual cycle for your issuer, and you are obliged within 10 business days to report out the occurrence of a material event to the municipal bond market through the EMMA website and information repository. If you have material non-compliance, this rule instructs you that you must disclose that. So let's just pretend your issuer has a glitch and you miss a couple of annual reporting filings, or they're done significantly late, a couple of years. You'll consult with your legal counsel. Maybe you wind up determining, yeah, that was material non-compliance. This rule will require you, when you go to issue bonds, you're going to include in your next official statement a mea culpa statement, if you will, an admission that you had the glitch, you took the measures to repair the glitch, and you are, in essence, going to be required to report that out for a 5-year window. The material noncompliance rule requires a 5-year look back and ongoing disclosure for a 5-year window with respect to that. So we talk about material events. We are not going to run through every item that is on this slide. It's important that you review this. Every continuing disclosure certificate that your issuer has approved and signed in the past includes this list, or as we'll note here, it may be a shortened version of the list. The 2 items in red are brand new items. They have been added just, I don't know when the rule was actually approved, but it went into effect about roughly a year ago.
February 27th.
This is live action law right now. Items 15 and 16 we are going to spend a little bit of time on. If you review this list, you're going to see some of them are quite intuitive. You have a default on a bond issue. You probably need to report that out to the investors. You have a rating change, positive or negative. You're going to report that out to the investors. Again, keep in mind, these are the real-time events, 10 business days after the occurrence of the event. We need to be getting a filing out on this EMMA website information repository announcing the occurrence of that event to the municipal bond market. Let's give you a little bit of an overview of these new events. There are 2 of them. As you can see, they're now items 15 and 16 on the material events list. The first one of those, I can tell you, is probably the more frequent of the 2. And so if you're only going to pay attention to one of them, I'd pay close attention to item 15. They're both important, folks. But item 15, I think you're going to hopefully find will occur more often, more naturally in the regular cycles of your issuer. Item 15 says that the incurrence of a financial obligation of the obligated person, for your purposes, think your issuer, if it's material, there's that word again, or agreement to covenants, events of default, remedies, and so forth, if that happens, if your issuer incurs a new financial obligation or enters into some contractual types of promises, if the financial obligation is material, we have to report it out. So, what does financial obligation mean? If you look down below at the definitions, you're going to see some operative terms: a debt obligation, a guarantee of another entity's debt, a derivative instrument entered into in connection with or pledged as security or a source of payment for an existing planned debt obligation. For many of you, this will be, instead of going to the bond market, we did a private placement with a local bank. Or if you're a city or a county, for example, who borrows through a state revolving fund loan program or a USDA rural development loan program, maybe for infrastructure type needs. A loan like that would almost undoubtedly be a financial obligation. And so what this rule change has done is it's made it a reporting requirement in real time to notify the investment world if you've entered into these non-bond issue financial obligations, other types of credit deals primarily. The question will be, are they material? And that's a question that we would encourage you to consult with your legal counsel on. We do think that the principal amount or the dollars involved with the new financial obligation do have some impact on materiality. So if it's a very, very small photocopier lease and you're a larger issuer, we may wind up determining that that's not material. But you do want to consult with legal counsel so the particular facts and circumstances can be taken into account.
And on that point, I'll just say the one item I think to be very cautious about here is there might be a number of contracts, arrangements with developers or things of that like where you're actually entering into an agreement to rebate monies to them if they reach certain conditions, so on and so forth. Those, again, based on materiality and some of the facts, can indeed be a financial obligation for which you need to report. So those, I think, are the traps for the unwary for the folks on this phone. I will also just point out one of the items we've run into very recently are, I'll call them legal structures with other municipal entities. So I'll use by way of an example, if you're in metro areas and City X may provide sewer or water services in conjunctions with cities A, B, C, and D. And so they have some kind of separate authority created or what have you. When that authority might go off and issue for the 5 or 6 sub-entities, that may cause the sub-entities to be entering into a financial obligation that very well could be material and might therefore trigger the requirement to provide information about that financing at an authority level with as part of your events under these new listings.
Yeah, there are all kinds of reasons under the federal tax regulations why you need to be keeping track of any intergovernmental compacts or arrangements that your issuer has entered into. This is a big reason under federal securities law, because debt that is issued to the benefit of your issuer by that or under that intergovernmental compact may very well have ramifications for you, and in particular, as Dave notes, may be a reportable financial obligation of your issuer. All the more reason why you need to be monitoring these types of things, and if you have any questions, you need to be consulting with your professional advisors and your legal counsel about whether or not it would be advisable to report. Item 16, hopefully, will not occur as frequently in the life of your issuer because it is, as you can see from its terms, more of a default or financial difficulties oriented reporting requirement. But certainly you need to be aware of it. If you had a local bank deal where you're, maybe it's a revenue-based deal and that enterprise or utility is struggling to come up with the money to pay on time, and so you're negotiating a new set of terms, there's some financial difficulty on that system, that would be the type of occurrence that should have you on high alert about item 16. These are fairly new. We should note, Dave will know the effective date right off the top of his head. February what of 2019?
27.
February 27, thank you, of 2019 is really the effective date of the rule. So it applies to any issuers that have issued bonds out into the bond market on or after February 27, of 2019 and adopted a continuing disclosure undertaking in connection with that debt issuance. So if you're listening and your issuer has not yet issued any bonds since 2018 or earlier, you probably are not yet in a position where you're covered by that, and you won't be until you issue bonds again. But if you have been out in the bond market, you've done a continuing disclosure certification since that date, then you most certainly are covered. You need to be aware of it, and if you've got any questions or concerns, do be consulting on it.
All righty, thank you, John. I think while we're at this point, one thing, and we're going to cover it here a little bit, but in a minute, but the events 15 and 16, I think, and some of the pronouncements from the SEC, you'll also hopefully understand and see the interweaving with adoption of policies and procedures by each of you as issuers. So I'll talk a little bit more about that, but in order to try to give you the benefit of being able to comply with all these material events, and now especially events 15 and 16, that is why it is really important that you folks as issuers adopt policies and procedures, and I would submit most importantly that you do refresh your memory with respect to those, especially with regard to staff and your counsels and supervisors and so on and so forth, all the elected officials. All right, I'm gonna turn to now slide that begins evolving role of the SEC. We're going to talk just about a couple things to just kind of give you a sense for what has occurred over the last 4 or 5 years. I would submit to you, as John talked earlier, about the differing roles of bond counsel and this ever-expanding concept of disclosure counsel. A lot of that really emanates from the SEC taking a much more active role in the municipal securities world than they probably had in the past. I think we lived in a world predominantly before about 2012, 2013, where most of our issues were really tax-driven, and so we were much more focused on the IRS. But now, over the last 7, 8 years or so, certainly we're now we're definitely as focused, if not more focused, on what the SEC is doing. You'll see there on the slide, action by the SEC has really taken on a number of forms. First, in 2013, some issuers were charged with fraud simply for what they had misstated in their continuing disclosure agreements. Some of those issuers were actually quite small in nature, very small school districts, very small municipalities. That certainly got everyone's attention. Then, more importantly, in 2014, the SEC started a program referred to as MCDC. Lo and behold, I've sort of forgotten. It's the Municipal Continuing Disclosure Cooperation, which it was anything but cooperation. We tried to forget. Forced pain, but so that commenced in 2014. It led to, in 2015 and 16, settlements by many issuers. I think there were approximately at least 2 to 3 that were required to actually enter into settlement agreements with the SEC. Probably more importantly, actually, the investment banks that were part of the municipal world all had to pay quite a hefty fine for what were viewed as some of their indiscretions in making sure your compliance with your continuing disclosure rules was robust. As a result of that, you've all seen when we talk to you folks and carry on due diligence, that has caused a very, very scrupulous review of all your past compliance. The rule requires, thankfully, at least through limitations, that we're looking back and reporting only for the prior 5 years, but nonetheless, where there were sections in offering documents and review of past compliance was not given near the attention that it is currently. Recent trends, and I won't talk too much about this is a little more for us as practitioners to follow, but just so you're aware, through remarks of the chair of the SEC in phone calls and so on that many of the professionals you all work with attend, there certainly is a call for much more timely, ongoing financial reporting by the SEC. The SEC is limited to some extent with their authorities. One thing that I think will be occurring yet this year is you'll start to see on Emma, which is your website portal where all of your continuing disclosure information is reported, what will now be a transmission calculator, which will essentially front and center, as I understand it, notify any investor as to how long it's been since financial information of you as an issuer has been reported by you in compliance with your continuing disclosure agreements. You are certainly, when you're reporting anything, dating it, and it would seem rather obvious that an investor could look to see at which date it was filed, but I won't make any more comments on the transmission calculator. I'm going to move on in the interest of time to some guidance that we recently received. And for everybody on the phone, I really, really cannot recommend more. You'll see the site hyperlink at the bottom of the page. The SEC on February 7th released a new bulletin with regard to continuing disclosure, disclosure generally, and so on and so forth. I'm going to highlight just a couple issues. It's about a 15 to 20 minute read, and I would really recommend that everybody take the time to print that off. We're going to be doing some more by way of getting this distributed to everybody, but I would have all the staff and all elected officials just take the 15 to 20 minutes to read this bulletin. The highlights are, as you see there, providing some general information about how the SEC views websites and how websites do come into play. John talked about 10b-5, but how information on your website comes into play in looking at the totality of the circumstances for the information that you're providing out to the public and its accuracy. They also talk about the historical information you may have online and the very key importance of making sure it's dated so that an investor, if they are looking at your website and if you may have always provided your CAFRs or your financial information and you look and it goes all the way back to 2005, first of all, I would urge you to take a look and consider whether some of that is now time to be removed, but more importantly, it's just making sure that that is dated correctly. Also, some discussion about hyperlinks, and again, reminding us there was some time ago, I want to say it was 2007, I may have that date wrong, but the importance of, if you've included hyperlinks in any of your materials via website or otherwise, that you make sure that it's very, very clear to the investor if they're going to another site, that that site is not information you're necessarily providing. Also, there's a very nice discussion about any financial performance that might be provided in an ongoing basis in a summary fashion, and the importance to make sure of its accuracy. A recognition that you're also presumably making some reports to other state entities, and the need to make sure that those reports are mirroring up with the financial information you're disclosing. And then probably most importantly for the purpose of this group is statements that are made by municipal officials. So I think there's a very nice discussion in this bulletin about the fact that when public officials are making statements, and presumably they're being made in a medium, whether that be speeches, internet, or so on and so forth, that you do have to be cautious, and you don't get to just make broad, bold financial statements that have no basis in reality with respect to the issuers that you serve. So it's a very nice reminder. Again, highly urge everybody to review it, and I think you'll be seeing another webinar from us that will probably talk just about this bulletin. I would also say this about the bulletin. It's a very nice summary history of where we've come, both for primary offerings in 10b-5 and the interplay with your primary offerings and your secondary compliance under 15C212, which emanated back in 1994. So can't recommend that everybody read that enough.
And Dave, if I could just briefly, I think that slide, more than almost anything else in our deck, should highlight for those of you who aren't really familiar with the municipal bond market that when your issuer closes on a bond issue, as much as it may feel like to you at City Hall that was just like going and doing a loan with a bank and that you've got your proceeds now and that you're basically done with it, the bond market is a different environment. These are securities that your issuer is putting out there. And those securities are going to be bought and sold and traded until they get finally paid off. And to me, that slide that Dave just ran you through really highlights the viewpoint of the regulators that the ongoing information that your issuer is putting out there into the world that might reach those investors is important, and it is covered by these regulations as well. If we're going to go out into the municipal bond market, we have to be truthful and accurate and mindful of our financial message all the while that those bonds are outstanding. Anyways, I'll turn it back over to Dave.
I think that's really a great point, and hopefully it's not lost on anybody. And maybe the last week, what's occurred in the stock market for various reasons is a highlight to that. Now, when you folks issue your debt, that debt may be traded multiple times before the debt is ultimately paid off at maturity in 10 or 20 years. And I think that is a change that has occurred dramatically over the last 10 years, where, not to date myself, but 20-some years ago when I entered into this business, it really was a situation where when municipal issuers went and sold debt, whoever bought that debt really intended to buy that debt and hold it till maturity, and that's what happened. And so this whole concept of your bonds or your notes being purchased in 2010 and maybe being traded 100 times by the time you get to 2020, that's just a foreign concept. It's not foreign now. You folks, and when you issue bonds or notes, you need to think of it as being Microsoft stock or Amazon stock or Tesla stock. And folks are moving in and out of trades constantly with respect to your debt. And so that's what the SEC is focused on. They're focused on now saying to you folks as municipal issuers, hey, the information you provided 10 years ago, that's not good enough anymore. You have to be updating your information appropriately with respect to the rules that have been set forth pursuant to C-212 and your ongoing continuing compliance agreements. So with that, I'm going to move into policies and procedures. I'm just going to quickly ask, we've got about 8 minutes. Any questions yet? Are we good? Okay. All right, so I alluded to earlier now the importance of having policies and procedures, and a nice segue if I don't say so myself. The policies and procedures really are about what John just really focused us on, which is, folks, now you've issued your bonds, but that doesn't mean the documents just get put up on a shelf not to be seen for another 20 years. You've got to be attentive now to what you've said in an ongoing basis. And so that's really, there are three aspects then of the policies and procedures that we prepare for folks. The first portion of the policies really go to what we'll call the primary offering. So that's preparation of, as John mentioned, the POS and the OS. You're now about to go out on day one, issue bonds, get the bonds priced and sold, and then you're going to receive the proceeds from the sale of those bonds and use it to construct the project that you described in your offering documents. The second aspect of those policies, though, is now what we've been talking about with regard to Rule 15C212. And that's making sure that you're monitoring those material events we talked about and making sure that, again, you're providing updated information to the extent you have those events occur within 10 business days of the occurrence in compliance with Rule 15C212. Lastly, a part of the policies is that you actually get your elected officials and staff to take part in this seminar that we do each year, so that they have some ongoing understanding of what it is that they're required to be doing and or not doing, with the recognition that elected officials come in and out of office, and for some of those folks, this is all somewhat new topic area for them. Let me talk first about preparing an OS. I'm going to kind of try to shorten this a little bit. I think the main point I would make about preparing an OS is, number one, now making sure in our policies that there's a methodology, a roadmap for who's involved in preparation of that OS, making sure that it's timely provided, the POS, to elected officials, to give them some time to peruse it, ask questions, certainly, to the extent that they may have any questions about what's being disclosed, and generally make sure that the entire finance team, from staff to elected officials to municipal advisors to the legal team, are all comfortable that you're providing any material information via the due diligence process, but also, probably most importantly, that you're not omitting to state something material that folks think would be important for investors to know as they get ready to issue debt.
If it's not obvious to you, this is a regulated document. The regulators consider it to be the issuer's responsibility to make sure that that document is free from material misstatements, that it's not fraudulent, and it doesn't fail to report any material risks that investors might face. The official statement is your issuer's document.
That's a good point. And I would also say all the parties involved, both legal counsel because of the opinions we give, and your financial folks, because of their regulatory environment and their due diligence requirements, we all have vested interest in making sure we get it right. And so we know we ask a lot of questions. We know it's burdensome. We know it's a pain. But quite frankly, we all have risk both financially and from a regulatory perspective to all get it right. So I would say we're all in the soup on that one. All right, I'm going to skip over. So that's kind of for a primary offering. Let me just talk now a little bit about meeting your MC or your continuing disclosure obligations. So again, in our policies and procedures, we set forth a disclosure officer or officers who are tasked with making sure that some of those material events we talked about, if they're occurring, they're being timely recognized and getting filed on EMMA through material event filings. Part of our policies are making sure that if you're entering into new continuing disclosure certificates, that the information that you're going to be updating, usually contained in your Appendix A's and financial information, is cohesive with your other filings and information that's appropriate to continually be provided. Our policies also help provide the disclosure office kind of a tabular information so that you can hopefully help keep track of all of these things. We also here at Dorsey do have other folks, and as John mentioned earlier, we do a detailed review of your continuing disclosure at the time you're issuing. So hopefully we're catching any missteps there and getting them to you when you're issuing timely. We provide a report to you, quite extensive report. I'm sure a lot of you don't care to look too much at it, but usually if there are some issues, we'll sit down and walk you through that. I would also urge in our policies and procedures, we've mentioned EMMA. We haven't talked much about EMMA. EMMA is the website portal, just as a reminder, that is the portal of choice by the SEC and the MSRB for which you to file information. Just as a quick aside, you do not get off the hook from your continuing disclosure obligations if you think you've put your financials or other information timely on your website. If you've hired an independent third-party entity website, it is EMMA. The information must be on EMMA. It must be linked appropriately to the QSIPs and so on and so forth of your issuance. I would highly urge everybody as well to take a look every once in a while for those folks who are responsible for disclosure at your different issuers. Take a look at your EMMA website occasionally. There have been instances where, quite frankly, information has been appropriately filed but didn't quite get on EMMA correctly. There has also been a number of instances we've run into where other issuers' information may accidentally get put on your EMMA website. So Burlington, Vermont may show up suddenly on Burlington, Iowa's EMMA website, and obviously, steps should then be taken to make sure that type of situation gets cleaned up.
Please keep in mind with all EMMA filings, they are not only a communication to the investment world, they're also a direct communication to the regulators. And so if you're posting information onto EMMA, obviously your normal annual report's probably not a big deal. But other types of situations, you may very well want to consult your financial advisors and your legal counsel in order to make sure that the message is being managed appropriately.
And I know we're probably at time, so I'm just going to say, in summary, again, part of the policies are obviously to make sure the governing body goes through biannual training, and that appropriate procedures are in place, that elected officials are also made aware of what's being disclosed at all times. So a couple key takeaways in conclusion. Disclosure responsibilities now certainly don't end after you've issued your debt. There's both annual reporting disclosure through your continuing disclosure certificates and agreements we've talked about, and certainly now more than ever because of new events 15 and 16, especially 15 as John noted, you have significant material event disclosure that you need to be cognizant of. The SEC is ever present, and I don't think that's going to change. In fact, I would submit that it's only going to increase in terms of the regulatory policy you folks are going to be scrutinized with. And just in general, the concept there is if you're going to go to the securities market, and again, we're talking about you issuing debt that is a security, and so the SEC is going to try harder and harder to play a more prominent role in regulating that arena for all of us. So with that, I don't think we have any questions. We're a little bit past time. Thank you, everyone, for indulging us for the past hour. And if you have any questions, you should have, I think, all the names of our group in these materials. Please don't hesitate to contact us, and let's be safe out there.